So I'm John Nectarline with TPI, and I'm delighted to introduce my co-panelists. To my left, we have Kate Stetson, who is one of the nation's leading appellate lawyers. She's co-director of the appellate practice at Hogan Lovells, and she's also a member of the UVA faculty, which makes me happy because I'm from Charlottesville, and I also will be teaching a class at UVA next fall. And next to her is Jim Speta from Northwestern University. He's a leading law professor on subjects that are quite relevant to this panel. Administrative law, constitutional law, antitrust, and telecom. So last month we heard a lot of news coverage of Trump's first 6 months in office, sort of a retrospective on what he's done. We heard to a lesser extent about what the Supreme Court has been up to for the last 6 months as well, as it confronts a flurry of legal challenges to Trump administration initiatives. And a lot of that analysis is focused on Supreme Court cases that are in what's called the shadow docket. So I'm going to turn to Jim and ask him to give us an overview of the Supreme Court's caseload and the new prominence of the so-called shadow docket. So Jim, take it away.
The shadow docket, which is a relatively recent description of the court's emergency docket, is where the court is usually asked to make stays in ongoing lower court litigation. Traditionally, think of stays of execution and death penalty cases, but given the flurry of litigation, it has resulted in a lot about new Trump administration initiatives. It has resulted in a lot more action in the Supreme Court for stays of other kinds of cases, civil cases, cases against the government. Now, there was some of this in the Biden administration or even in the Obama administration, as those presidents too used regulatory authority to seek to do new things such as expand the scope of EPA actions on climate change. But to get to the numbers, just so you have a sense of this, last year there were only 44 matters on the shadow docket at the Supreme Court. So far in this year, there are 113 matters, and in Supreme Court time, the year doesn't end until October. So a lot more action there.
So Jim, when the court issues an opinion in the shadow docket, to what extent is it foreshadowing what it's going to do on the merits in that case, if it takes the case?
Well, two things. First, sometimes it doesn't say much of anything at all or nothing at all. But second, to the extent that they say something, it is at least reflective of the majority that entered the stay or entered the order, as it may be. Now, sometimes we get concurring opinions and sometimes we get dissenting opinions, and those sometimes shed perhaps some light on what the majority may have been thinking. But sometimes we don't exactly know what the votes are. If there are 3 articulated dissents, the majority might have been 5 or 6. And so I think Kate's much more expert at reading all of those tea leaves in actual cases. So, but I'm cautious about reading those tea leaves, except for an exception we'll talk about later, where
Okay.
I think the tea leaves are pretty clear.
All right, Kate, let's have you read the tea leaves. The Supreme Court has ruled for President Trump in almost all the shadow docket cases. And there are 2 hypotheses out there about why that is so. One hypothesis is that a majority of the court actually thinks that what Trump is doing in these cases is good and constitutional, and they're happy to uphold these things on the merit. The other explanation is that they are keeping their powder dry for a politically propitious time to stand up to the Trump administration's invasion of what some of them view as constitutional affronts. So there are 2 hypotheses. One is agreement, the other is appeasement. Where do you come down?
I think the answer is both and. And let me unpack it a little bit because I think some additional numbers are important. You heard from Jim about the number of shadow docket cases that are currently pending. That, of course, traces back to what you heard Jim and John refer to as the flurry of litigation, which in turn traces back to this. Since the Reagan administration, every president has issued on the order of about 43 executive orders per year since 1980. So far in his presidency, Trump has issued 191 executive orders. So the flurry of litigation is in response to a tsunami of executive orders. Some of those executive orders, of course, have been enjoined by the lower courts, and some of those have been appealed to the Supreme Court, but not all. So when we talk about the Trump administration's winning record in the Supreme Court, I think it's important to understand, and Jim made this observation yesterday when we were chatting, that is a selectivity characteristic of the Solicitor General. The SG is not picking all of the fights that he is having below. I can think offhand of about 10 cases in which the president's executive orders were enjoined that the SG hasn't touched on appeal.
There are currently 48 such district court opinions.
Yeah. So see, you do know the stats. This is good.
So give us an example of a couple of these cases where the SG has actually acquiesced in losses in the lower courts.
The medical the funding to providers of gender-affirming medical care. There are 3 injunctions currently extant against the administration, precluding them from yanking funding from providers of gender-affirming care for minors. None of those have been taken up to the Supreme Court. All of the law firm executive orders that you heard so much about in February and March, all of them have been enjoined. None of them were taken to the Supreme Court. You know, I could go on, but those are probably the most prominent ones I can think of. Okay. But just one more point on the majority issue. When we talk about what these stays are, Jim mentioned that sometimes, and this is important, the majority that grants the stay doesn't even explain itself at all. It just says the stay is granted, pending appeal, pending disposition of a petition, QED. But I think it would be a bad mistake to assume that there is some monolithic response from the majority in the Supreme Court to that petition. I think there are 2 members on the Supreme Court who, if they could, would wear red baseball caps to court every day.
No prizes for guessing who they are.
And the statements I make are the statements of me alone and not Hogan Lovells and not TPI. There are other justices on the court who care very much about scope of remedy. And a lot of the stays that you've seen have to do with a disconnect between the remedy that was given and a remedy that might make more sense. There are other justices who are very concerned about the nature of a presidential prerogative. That combination of interests serves to make a majority in many of these cases. So it's not monolithic, it's incremental, I think is the answer.
Well, let's drill down to a specific case to make all this a little bit more concrete. And let's talk a little bit about the birthright citizenship case, Trump v. Casa. Kate, will you walk us through what the underlying dispute is and how the litigation has progressed through the courts?
Sure. So the underlying dispute emerges from an executive order proclaiming that despite what we all understood the 14th Amendment to say, children born in the United States of parents who themselves are not citizens of the United States, in fact, are not citizens of the United States. The 14th Amendment, for those of you who don't know it by heart, says, I can't quote it verbatim, but all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. It has been the case since at least 1898 in Wong Kim Ark that what that means is that a child born in the U.S. to non-citizen parents is, with the exception of diplomats, which is where that subject to the jurisdiction phrase is important, a citizen of the U.S. So a number of different plaintiffs filed lawsuits, individuals, states, and organizations. a district court granted a nationwide injunction, also called by the Supreme Court a universal injunction, forbidding the Trump administration from acting on that executive order across the country. The Solicitor General took that up on appeal, and only that, and this is something that you see the dissent make a lot of, the Solicitor General really didn't defend the constitutionality of what that executive order said. You know, hot tip, he can't. What the SG said was, this national injunction has no basis in equity and has no basis in the facts of this case. And so what you saw the oral argument and ultimately the decision turn on is a question of the nature of what has become known as the universal injunction, a relatively recent thing, when it can be, if it can be imposed, and on what terms.
What are the practical effects of the Supreme Court's ruling in that case?
I think the practical effects are less seismic than people might be given to believe. It, I think, should be the case that if you are an individual plaintiff suing the government, with the exception, one important exception, which we'll talk about, you shouldn't be able to obtain for yourself an injunction that applies naturally. That might be different if you are a state. It might be different if you are an organization. And that, of course, is what the Supreme Court sent the case back to the district court and the circuit court to decide. But the one important exception I want to point out, and I'll go nerdy for a minute on footnotes. Footnote 10 of Justice Barrett's opinion, I think, is a key administrative signal. Footnote 10 is the one that says nothing in this opinion essentially should be construed to indicate our opinion about section, I think it's 705?
706.
706 of the APA, which says a district court shall hold unlawful and set aside any agency action found to be unlawful or arbitrary and capricious. That is a different kind of universal remedy subject to the Administrative Procedure Act. So all the things that we're talking about right now are challenges to executive orders. They do not fall under the APA. Once you get to the point in time where all of these agencies are implementing those executive orders, that universal vacator question is going to come to the fore. And you've had both administrations recently challenging the idea that Section 706 actually stands for universal vacator. Hot tip, it does. So that's going to be, I think, where the real practical battles are going to be fought, in the coming months.
Can I just add that the court also acknowledges that class actions don't fall within this. And immediately after the court's opinion, I think it was the same afternoon, the birthright citizen challenges were refiled as class actions. Now, the Solicitor General in oral argument said the United States will oppose the class actions, or at least in some circumstances. My view is that class actions on constitutional facial challenges should be readily granted, but I'm sitting on the left side of this panel, so. But that applies to conservative actions on constitutional rights as well, so.
Yeah. Do you, the two of you think that the dissent in that case was exaggerated?
No, I don't. I took the main message of the dissent to be essentially the classic legal, come on. Like, you have an executive order that is profoundly on its face, patently unconstitutional. And we're here debating the finer points of equity in the late 1780s with respect to whether or not universal injunctions are a thing. Come on. I don't think it was particularly overwrought.
But there was also a lot of discussion about the practical effects of the decision on children of undocumented immigrants.
It's true, but that's the nature of the dissent, right? The dissent in any Supreme Court case, and you can pick up some great Scalia dissents, for examples, tend to be a little bit higher on the Scoville scale of pepper, right? And that's the dissent's prerogative.
The court has expressed its concern about universal injunctions for some time, and there have probably been a couple of dozen of cert petitions that the court could have taken. In fact, I think it digged a couple where it tried to address this. But it sends to me an extraordinary signal to have chosen this case to address it. I have other problems with the majority opinion, which I just think is wrong on the history and wrong on what the nature of equity is, but that's a different point.
Well, and the majority did point out that concerns about universal injunctions have been historically bipartisan. So they were, in fact, I think there was concern about them in the Biden administration as well. Litigants would rush to the Northern District of Texas to get universal injunctions.
Yep.
Let's pivot to a different case that has also appeared on the shadow docket recently, and that's a case involving challenges to Humphrey's executor. And I noticed, without any of us guiding this, that will Humphrey's executor be overruled is a question on one of the whiteboards out there. And it's a great question and may have quite a lot of significance for agencies that are important to people in this room. So, Jim, take us through what Humphrey's executor actually held and how it has mattered to the independence of agencies like the FTC and the FCC.
So, as quickly as possible, given the long history here, in 1935, Humphrey's executor was decided by a unanimous Supreme Court on the same day as Schechter-Poultry. And I think that's important because in Schechter-Poultry saying that legislation had delegated too much authority to the president, the court also wasn't going to allow the president, President Roosevelt, to turn around and have essentially the same authority through having the ability to fire commissioners at the FTC who didn't agree with him. And so the court upheld the constitutionality of for-cause removal protections for executive officers who are not purely executive officers. And this means for the independent commissions, the multi-member commissions, that Congress could provide for-cause removal protection. That case stood, even though those who align with the formalist and the originalist schools of separation of powers had long criticized it unchallenged and really remarked upon by the Supreme Court until 2010, when it said, we sort of have our doubts about this, but Humphrey's executor is still the law for multi-member independent commissions, and one other or two other examples, depending on how you count. The court, in two opinions in 2020 and 2021, reaffirmed that Humphrey's executor still allowed for-cause protections to multi-member independent agencies. President Trump has now, that's the background. Mm-hmm. Until this administration, the DOJ had never expressed any request to overrule Humphrey's executor or any challenge to Humphrey's executor, so that's where we are with some of the executive orders that fire many members of many independent commissions and do not try to state any cause for doing so, including the FTC, the NLRB, the Merit Systems Protection Board, et cetera.
Yeah, so I used to work at the FTC, and we were always proud of what we considered to be its bipartisan nature. And it's not a bipartisan agency anymore because the president fired the two Democratic commissioners in the spring. And it is now entirely a Republican commission, and the head of the Republican Commission, Andrew Ferguson, who was here last year, has been outspoken in saying that he thinks Humphrey's executor was wrongly decided and the president should have the freedom to hire and fire commissioners as he sees fit. There is now litigation brought by the fired Democratic commissioners of the FTC that has been percolating through the courts, but there's also another case that actually got to the Supreme Court first. Jim, do you want to take us through that one?
Yes, this was a commissioner of the NLRB, or the one that's surviving is a commissioner of the NLRB who was fired without cause. The district court said Humphrey's executor is still the law here. This is illegal, and issued a reinstatement order. The government went to the D.C. Circuit for a stay of the reinstatement order, and the D.C. Circuit panel, 2-1, granted it, saying, we think Humphrey's executor is on its last ropes, and by the way, there might be an exception here. We won't get into the details there. The en banc panel set aside the panel's order and reinstated the district court's stay, and then the SG went to the Supreme Court, and the Supreme Court issued a stay of the district court's reinstatement order.
So this was also in the shadow docket, but this
Yes.
is one of those cases where they did issue an opinion that was extremely terse, but what did it say?
Well, in 4 paragraphs, it moved the ground significantly, in my opinion, on the continued vitality of Humphrey's executor's protections for independent commissions, for cause removal protections. It did so in 2 ways. It said, as to the NLRB, it exercises executive authority and distinguished that from Humphrey's executor, while, of course, the FTC in 1935 did exercise executive authority. The decision was it wasn't purely executive, but also quasi-legislative and quasi-judicial. So maybe the court is just uncomfortable with that and will overrule the reasoning of Humphrey's executor outright. But the thing that has always in some way protected Humphrey's executors to some extent is what we call the Fed problem. If the president can fire any member of any commission, the president can fire every governor of the board of the Federal Reserve immediately. And everybody seems to think, or at least used to think until a few months ago, that Fed independence was a bedrock of the US and the world economy. Well, in this opinion, instead of referring back to saying Humphrey's executor is good for independent commissions, the only sort of thing it said in addition to this executive point was to say, petitioners argue that if we're not protected, then the Fed isn't protected. But the Fed is a long-standing institution like the first and second bank of the United States. And that's a new way to think about things from the Supreme Court, which suggests that Humphrey's executor could be overruled for everybody except the Fed.
So how would
Can I make a
Yes, please.
couple quick observations? So first is, Jim is exactly right. The reasoning is, the Fed is different because bank. That is not that is a factual distinction that if you were arguing that to this court, they would say that's just a factual distinction, that the Fed is independent, these are independent. But Jim's point about the purely executive nature of some of these independent agencies, I think, is where the rubber is going to hit the road. I think what you're seeing in this shadow docket opinion is that there are people who are at least willing to significantly narrow Humphrey's executor, perhaps not overrule it outright, but essentially cut all of the legs out from under it by saying any quasi-independent agency that exercises significant executive function, therefore is actually an executive agency and not an independent agency.
Let me ask a pragmatic question about this. Do you think let's say the Supreme Court in an alternative universe decided to reaffirm Humphrey's executor. That doesn't mean the president can't fire the heads of agencies he doesn't like. It just means he has to concoct some cause-based rationale for doing it. And that doesn't seem difficult for this president to do. In fact, I think he's already sort of laid the groundwork for that if he ever wanted to fire Jay Powell at the Fed by claiming that he had somehow engaged in fraud in the renovation of the Fed building. So all this is interesting from a legal perspective. But if the president used some pretext like that to fire an agency head, what would the courts actually be able to do about it as a remedial question?
As under the law as I understand it today, issue a reinstatement order or a back pay order
So
or
would that require
something like that.
issuing an injunction against the president himself?
Well, A, I'm not uncomfortable with that, but B...
Has it ever been done? Has it ever been done? And if not,
No, it's not been done
why
before.
hasn't it been done?
Why hasn't it been done before?
Yeah, why hasn't the Supreme Court ever joined the president?
It's just reluctance, I think, to do so. It feels like more of a constitutional crisis to say to President Nixon, you have to turn over the tapes, than to say to the National Archivist, you have to turn over the tapes. I don't know.
But I mean, in the D.C. Circuit opinion in the Wilcox case, you have Naomi Rao's dissent. They're really focused on that remedial question. She said, if Humphrey's executor is upheld, the best relief that the fired commissioner could get would be back pay, that the courts have no business exercising their equitable authority to force everyone in the executive branch to pretend as though the president didn't do something that the court considers unlawful.
I don't necessarily agree with that, and here I think the history is on our side, is on the side of my argument, which is the long-standing theory of equity against the king or queen in England was that you could grant full relief against the officers who worked for the king or the queen on the theory that the king or queen can't break the law, but any of his officers can be held to be acting ultra vires if they're doing it. But I think my more fundamental point is that there's a feedback effect between norms and laws, right? And what we are engaged in here is an enormous amount of norms testing. And the norms will break faster if the laws are not upheld.
Let me chime in quickly on that, because I think I disagree that there's something that a court would do in the circumstance where the president cites a cause and dismisses somebody, because I think you get into questions of standards of review and deference to the executive's prerogative and all of those things. So while it's theoretically possible for the court to order reinstatement, I think it would be very, very difficult. That in turn depends on exactly what Jim is talking about. There has been, until quite recently, a pretty solid norm that a president would not dismiss for cause someone where the cause didn't actually exist. But as one of the speakers yesterday said, and I wrote it down, norms aren't doing so well these days.
Yeah, that was Carl Shapiro.
Yeah.
I mean, it's an affront to Burkean conservatism to see what's happening to norms in this administration. It's my personal observation. So before we move on from Humphrey's executor, one last question about it. The FTC has always had a little insecurity in justifying its separate existence, given that there's another agency that does much of its work. So the DOJ, obviously, also enforces the antitrust laws. And one of the rationales for having a second agency like the FTC is that it's a bipartisan agency that is based on consensus, and it's a bedrock of stability. And there was a time when that was true. It's no longer a bipartisan agency, and for the last two administrations, it's been run by people who view themselves as leaders of ideological movements. And I think somebody else pointed out, I think it was also Carl Shapiro, that that makes it more difficult for the FTC to justify its independent existence, at least as an antitrust agency. The formal elimination of Humphrey's executor, I should think, would also be another strike against retaining the FTC as an independent agency, because at that point, both the head of the FTC and the head of the antitrust division are just arms of the president, right? The same president. What is the rationale for having two different antitrust agencies at that point? Any thoughts on that?
No. Honestly, what I would like to see is, if the court overrules Humphrey's executor, that it doesn't sever the for-cause removal and invalidates the whole statute. Because part and parcel of the amount of delegated authority to the agency in the statute was the protection and the creation of bipartisan multi-member commissions. This was the explicit deal done with the conservative Supreme Court in upholding under the Constitution the New Deal agencies and the progressive agencies. And one of the reasons we find ourselves in a very weird position right now is the overruling in INS versus Chadha of legislative vetoes, but severing the legislative veto from the rest of the statute, when I think it's fair to say Congress would not have delegated that amount of power to the administrative agency without the condition agreed to by the president in all of those cases of the legislative veto. The court keeps saying, we really want Congress to do its job. Then strike down the whole statute and see what happens.
Yeah, I mean, it's interesting because the court at least purports, when it's in the remedial phase of these cases, to look into what Congress would have done in the counterfactual world in which it knew that the for-cause removal protection would be invalidated. Boucher v. Sinar is actually an interesting case on the other side of this, in which the remedy was closer to what you're proposing. But it is conceivable, at least as a purely legal matter, that the remedy in the event that Humphrey's executor is overruled, the remedy would be invalidation of the FTC Act and effectively a remand to Congress to come up with a different structure for the FTC. I don't think that's at all likely to happen in reality.
Oh, I agree with that.
Yeah. But there's at least there's a decent academic case to be made for it. So we were going to talk about net neutrality, given the nature of the forum, but I think it probably makes more sense just to move on to audience Q&A, because these have been some really interesting issues we'd like to hear from you all in the remaining 3 minutes and 20 seconds that we have. Baron Soka.
What sort of statutory reforms do you think should be made coming out of this administration to deal with these problems, to the extent that there's room in what the Supreme Court allows, like anti-removal protections, explaining a removal, requiring a hearing, such as for the Comptroller of the Currency or the Inspectors General?
I think part of it depends on what, if anything, remains of Humphrey's executor. If I'm right that some kernel of it remains, you would think that Congress could do a different or better job articulating precisely what role this particular independent agency is to play, rather than vesting it with a lot of executive authority. So essentially buffering independent agencies through amendments to the statutes to point out their legislative and judicial components. That's one idea.
Alan Rawl.
Thanks, John. Great panel. 2 quick points of information. One, the president can always fire the heads of the FTC, SEC, FCC by redesignating somebody else as chairman. And also, I think in Youngstown, Cheat and Tube, didn't the court directly enjoin the president by declaring the executive order to steal seizure? In any event, I'm not sure, but in the interest of time, there are 2 you raised, John, the appeasement versus agreement approach to the president. There are 2 other sets of officials that the court has been pretty disrespectful towards. One is Congress, when Congress decides how to organize things. Even though, as Professor Speta said, they're asking Congress to do its job, but then when Congress does its job, they don't, and the court doesn't like it, they sort of disrespect the congressional, the legislative policy. The other is lower court judges, district court judges in particular. Maybe you could address that. There's been a striking lack of support from the Supreme Court majority to the district court judges. Maybe they think that they've, with universal injunctions, so far they've gone too far. But in fact, when you get on some of these cases, like the birthright citizenship and others, where all of the decisions are saying these orders are blatantly unconstitutional, and where they've done fact-finding, and then it goes up to the Supreme Court, and without any explanation or reanalysis, they reverse the district court and the shadow docket. What do you think about that relationship between the Supreme Court and the lower courts?
I think if I were a district judge these days, I'd be feeling pretty put upon. I think you're exactly right that the court, in word and deed, has not been backing its lower court components. You could see a number of those decisions being written different ways. You could see a number of the grants having some explanation behind them rather than just granting them. So I think if I were particularly a district court judge in DC, Maryland, Massachusetts, other places being inundated with these challenges and not feeling the backup from the Supreme Court, I'd be pretty peevish.
I think you can see the effect of it in the decision last week from the DC Circuit allowing firings to go forward. They finally received the message that the Supreme Court thinks the balance of equities is in favor of letting the president do his actions now and figure out the legality of them later.
Unless I'm granted an extension by Scott Walston, which is unlikely. Okay, all right. Yes, yes.
Appeasement or agreement? For those of you who think the Supreme Court is appeasing, what are they going to take their stand on, and what happens when they?
I'm glad we were given the extra time.
Appeasement is a tricky term, right? Because I don't, appeasement is, in my view, placating someone who you're worried is going to get angry. I don't view the justices, at least a majority of them, as being particularly concerned if Trump tweets something mean at them. I think, biding their time is perhaps more likely, and biding their time until they get to the merits of the issues in front of them, the merits of the birthright citizenship issue, the merits of Humphrey's executor. That is when I think, at least some of these cases and some of those justices are likely to take different approaches.
Yeah, I agree with that. And I think this is foreshadowed by the theory of our need for a vigorous executive that was in the immunity opinion, the Trump immunity opinion, and it's reflected in what I just referred to as the balancing of the equities in favor of letting the president act, et cetera. But the court is also not necessarily a favor of presidentialism in the sense of allowing the president to read statutes as broadly as they might be read. That's something that I know you talked about a lot last year with the Loper-Bright overruling of Chevron. And there will be cases, I presume, in which the statute will be read against the president, and I think the merits of Kate's exactly right. There is no colorable, non-frivolous argument in favor of the birthright citizenship executive order. There's just none.
Okay, well, that's an appropriate point on which to end. Thank you very much, both panelists.